Good morning. I'm very glad to welcome all of you to this European Colloquium. I'm very grateful that you have accepted the invitation, of course, and also that you have taken the trouble of a long journey. We know how far away Trento is from the main centers of transport, and so I appreciate very much your effort. We are going to have a discussion this morning and the afternoon with a very distinguished panel. Let me introduce for the morning panel, I follow the order, Valerio Onida, who is Emeritus Professor of Constitutional Law at the University in Milan and former President of the Constitutional Court in Italy. So as I was suggesting, we also have a voice from within the judicial establishment. And then we have Maribel González Pascual, who is a professor of constitutional law at the University Pompeu Fabra in Barcelona. May I just say how much I enjoyed teaching that university for 6 years, although not recently, who is now, because of her knowledge and expertise, is also working at the Ministry for Territorial Policies at the national government in Madrid. And so again, we have another voice from within. And in the morning, we have, we deal with two countries like Italy and Spain that are not federal. In the case of Spain, as you know, a number of definitions have been suggested, like quasi-federal, regional, federal, and the like. But certainly is let's say, a decentralized country and a decentralized country with some problems. And we have been discussing, and let me just add as a word of introduction, just that by talking with a number of colleagues last night and also this morning, it really came out how much what until a short time ago were regarded as domestic politics in member states are now issues of European concern. In fact, many people are curious, and so am I, about Italian politics, and so about Austrian politics, and of course Spanish politics. We just mentioned the Catalan question, and we know that yesterday there has been an important referendum in Switzerland, suggested somehow by the European Union. Because it has to do with arms, and arms, of course, are also a hot topic in Italy at the moment. So really, domestic politics intertwine very much with their proper European dimension. Now, I have good news for you in the sense that we're going to have a coffee break at 10:45, and after that, we'll start dealing with two federal systems, the one from Switzerland and Belgium, and we have the great pleasure of having Eva Maria Belser again here in Trento. She holds the chair of Constitutional and Administrative Law and is the co-director of the Institute of Federalism at the University of, I say Fribourg.
I say Fribourg.
Oh, you say Fribourg, okay. Okay. And then we have again the great pleasure of having Julien Pierret, who is the director of the Centre de droit public de l'Université libre de Bruxelles, and I welcome you in particular because it is your first time and hopefully not the last here in Trento. We have time for discussion and lunch. The weather is very cooperative since because of the cold and the rain, nobody will have the temptation of going around Trento. So that was not planned, but it is somehow welcome. I would like to say a few words of introduction to the proceedings of our European Colloquium. Now, the scientific purpose of this colloquium is to focus an aspect of federalism or regionalism, which is not often the object of research in comparative law, namely the extrajudicial settlement of controversies between the central government and member states, whether they are cantons or Länder or regions et communautés or comunidades autónomas or regions. judicial settlement of such controversies is obviously an essential structural and functional component of any federal, regional, or devolved form of government. And in fact, it is there to reflect the compound nature of the polity in its entirety. In fact, the very composition of the court in charge of such issues is very often also reflecting the compound nature of the polity. And I would also add that having a central judicial institution is an important element of distinction of a federal or regional or devolved system from a confederal one. And from this point of view, I would also like to add the supranational pattern of organization of a public power. And this, of course, holds true whether it is an ad hoc constitutional court or a Supreme Court. Now, let me add, just to enrich somehow the fact that the object is rather neglected in comparative research, that in Belgium, the original denomination of such a court was Cour d'arbitrage, and the very name witnesses by itself the very initial purpose of establishing such judicial institution. And if I remember correctly, there has been a first stage in which the competency of the Cour d'arbitrage, still with the same name, has been expanded to include issues of concerning the principle of equality, which once again has to do with the decentralization of the system, and then eventually the court became properly a constitutional court. In the United States, although this is a European colloquium, but when you talk of federalism, it is almost impossible not to mention the United States. The Supreme Court is often qualified as the umpire between the Union and the member states, and this again is quite often the case also in other polities. In other words, as the tension between national and subnational governments over competencies and resources is physiological in federal, regional, and devolved polities, it is just as physiologically that such tension in rule of law states be eventually decided in court. Nevertheless, most of such polities also favor, in law or in practice, through conventional agreements, attempts at managing such litigation at a prejudicial stage, rely on courts only if and when such other instruments fail to eventually achieve a mutually acceptable negotiated result. And I could mention a number of countries that have formalized this particular situation. Now, in Belgium, there has been an amendment to the federal constitution, and the reference is to the chapter number 5 de la Cour de la Prévention et du Règlement des Conflits. And there is quite a detailed regulation, and in particular, there is a reservation of a more detailed discipline in law to be adopted. In Spain, the organic law on the Constitutional Tribunal has been amended, and textually it establishes a bilateral commission of cooperation which has the purpose of avoiding the introduction of a complaint to the court. The Constitution of Switzerland, in Title III, Confederation, Cantons and Communes, has a section on cooperation between the Confederation and the cantons, and explicitly it says, disputes between cantons or between cantons and the Confederation shall, wherever possible, be resolved by negotiation or mediation. Now, I have already gone extraterritorial to the United States, and I'll do it again with the Constitution of South Africa, which is very clear from this point of view, somehow following the Swiss pattern the Constitution of 1996 has a chapter on cooperative government, which has a very long list of duties that provinces and the central government have to perform. And then it says that an act of parliament must establish or provide for structures and institutions to promote and facilitate intergovernmental relations, and provide for appropriate mechanisms and procedures to facilitate settlement of intergovernmental disputes. Plus, the same provision continues, an organ of state involved in an intergovernmental dispute must make every reasonable effort to settle the dispute by means of mechanisms and procedures provided for that purpose, and must exhaust all other remedies before it approaches a court to resolve the dispute. Not only, if a court is not satisfied that the requirements of subsection 3, the one which I just read, have been met, it may refer a dispute back to the organs of state involved. So I have left the South African Constitution as the last one because it seems the most detailed in emphasizing the importance of extrajudicial settlement, to the extent that a court may send the controversy back to the political institutions. Now, in spite of my age, I sometimes have a good memory. And I remember reading a long, long time ago, in fact it turned out that the book was published in 1980, a book which I found at that time and still find very interesting, which deals with the United States. The book is by Jesse Chopper, Judicial Review and the National Political Process, subtitle A Functional Reconsideration of the Role of the Supreme Court. I wrote here 1989, but it is 1980, so quite a long time ago. And he has, his thesis is the one concerning the disposability of judicial review in issues concerning federalism. He wrote that constitutional questions that concern the scope of national power vis-à-vis the state should be held non-justiciable. That's a very strong statement. Such questions should be left to the national political process for final resolution. In other words, what Chopper maintained is that federal issues should rely on what are known as the political safeguards of federalism, rather than making use to the judicial review, which must remain as the last resort. Of course, this does not apply in all cases. It relies only on cases in which the dispute concerns competences and resources of the central government and of the member states, but not when the issues concern individual rights. Now, in many cases, certainly in the history of the United States, questions of human rights have started or have become issues of federalism. Now, in this case, according to Chopper, the Supreme Court should have a role to play, not in what we might consider only only federal issues. I would add one element of my own as a footnote to Chopper's work. And again, I rely on the well-known conception of federalism as a process. Of course, I refer to Friedrich. And it seems to me that perhaps it is more in the nature of a process, not to rely on the judicial decision, which must necessarily say that it is as black or white. A process sometimes takes advantage from the gray, from an area which is not so finally and unequivocally defined as to allow for more flexibility in the future. For instance, in situations such as the one that we have experienced in Europe and in Italy from this point of view, quite a restrictive case law from the Constitutional Court may be related not on a general ground, on a general interpretation of the Constitution, but on the fact that centralization was, for the better or the worse, seen as an instrument for managing the crisis, not necessarily as an interpretation which should be structurally against the enlargement of competencies that the 2001 constitutional reform gave to the regions. So safeguarding the political process on the one hand and safeguarding the federal process on the other hand combine as a background for discouraging to make so much use of judicial review. Let me just add that I think in 2012 or 2013, or perhaps even for 2 years in a row, the litigation between state and regions has occupied for more than 50% the work of the Constitutional Court, and I don't think this is necessarily healthy. All right, so thank you very much again for paying attention to my introduction, but I thought it was necessary to provide a little bit of the background which inspired the organization of this European Colloquium to which you so kindly accepted to participate. Now, it is my privilege to give the floor to Valerio Nida for his introduction and for his dealing in particular with the Italian case, which from what I have said so far seems to be a case of Italy against the rest of Europe. So it is not a very comfortable situation, but this is not the first time that Italy occupies such a position. And of course, with your insight and balanced view, you'll give us an appropriate scenario of the Italian situation. So, Valerio, you have the floor.
Thank you, Roberto. But first of all, I have to apologize for my very poor English. I can't speak fluently English because, unfortunately, I couldn't practice language for a long time in my life, and I am old. I am 83. I asked the help of Professor Toniatti. Then, Italy was traditionally a very centralized country, a system, and constitutional system, also before the fascism, before the 20 years of fascistic regime. Our model was France, the Napoleonic model, with a very strong central government, limited autonomies at a communal level, and very strong controls of the central government upon autonomies. The traditional institute of the prefetti, the prefect is a traditional institution, is an agent of the central government sitting in the centralized seats. Then the Constitution of 1948 was also under this point of view a very hard novelty, because the Constitution provided for the first time a regionalistic system at a constitutional level. Regions with constitutional competences, also as for legislation, not only for administration. This is perhaps the most important novelty in the Constitution of 1948. But this Constitution came into political system, and administrative system, which for a long time was unvariated. At the beginning, also only 5 regions, 4 and then 5 regions was constituted in Italy, the special regions, and Trentino Alto Adige is one of them, for an international question of the existence of a German-speaking minority. Sicily, Sardinia, the Great Isles, Valle d'Aosta, that is another mountain region in the western part, and where they don't speak French, but they speak some, I don't know how, a dialect, what is it? More French than Italian, I don't know. And Friuli Venezia Giulia, that is the region in the northeast border of Italy, where there is a minority of Slovenian people. So the essential reasons for instituting these regions was the fact that we had regional realities with particular connotati, come si può dire, particular features, isles, mountains, and linguistic minorities. For about more than 20 years, the regional system in Italy was only the system of the special regions. And these 5 regions were not the most rich, the most important, the most populated regions in Italy. Then the Italian government and administrative system was characterized by a very strong centralism in continuity with the traditional system of the regime before the Constitution. Then when in the 70s of the past century, where other regions, all the regions, the ordinary regions were constituted, they were born in a climate that was not favorable to regionalism. It was a political choice, of course, to constitute these regions, but the structure of the state was consolidated as a centralized structure. We had prefetti, we had a very centralized financial system. And so the history of regionalism in Italy was a difficult history of a very lento, very slow process. Until the 90s, the political tendencies were more for restricting powers of regions. Only at the end, in the late 90s, when a new political party who was an expression of northern part of Italy, Lega Nord, Northern League, now it is the League, now it is at the government, but in the 90s, now the League is the oldest political party in Italy, because this we have to remember this. Italy lost its political system in the 90s, lost completely the major parties which were the protagonists of the political system in Italy, either scomparvero, either disappeared, or they transformed them deeply. Democrazia Cristiana, Christian democracy. No, it was a majority party for decades. The Socialist Party disappeared, completely disappeared, and the electorate of the Socialist Party became, in its majority, the electorate of the new party, Forza Italia, the parties of Mr. Berlusconi, which is not regionalist, not autonomist. It was a right party, a party essentially for economic liberalism. So, in the late 90s, the political process in Italy was rather scombussolato, insomma, rather screwed up. and the presence of the Northern League, which argued, rivendicava, which claimed from a strong autonomy, also for independence of the northern regions, made that the other parties, or some of the other parties, were concerned by this problem, and they gave life to a constitutional reform, a very deep reform in the 2001. A constitutional, the most important reform of the constitution we ever had in Italy. Other reforms were attempted, but they failed. This reform passed. It was approved by the parliament in 2001. It was approved in a referendum. In a referendum that didn't see a very high participation of people. I don't remember, about 35% of the electors voted that referendum, but the reform was approved.
Well, we should just say that this referendum has no quorum.
It has no quorum. Because it is a referendum for confirm or not confirm the deliberation of the parliament. The parliament had approved the reform with a strict majority of center-left. But the center right was not so deeply against this reform, because in the center right there was the Northern League. So the center left was for the reform, the regional reform. The center right was not didn't approve it in parliament, but didn't make a battle in the country for rejecting that reform. Then in 2001, the Italian constitution was deeply transformed, and it became apparently a very quasi-federal system. Because, for instance, in the original constitution, the regions had legislative and administrative competencies in such listed matters, and the general competence was of the central state. In the reform of on the 2001, the system was the contrary. There is a list of central competencies, a list of concurrent or shared competencies, and the residual competence is on regions. Then a quasi-federal system, and we have a paradox. This was a very regionalistic, autonomous, quasi-federalistic reform, But after 2001, the evolution of legislation, of administration, of the political system was most in the direction of a re-centralization, more than in the past, centralization. There is a real paradox, because in the years after the reform of 2001, the central legislation, the legislation of the parliament, the national parliament, was less regionalistic than in the past. An example, the system of shared competencies, it was provided that the parliament approved come si dice legge quadro? Frame legislation, and the region had to do the detailed legislation. Well, after the reform of 2001, the regions had shared competencies in a very long list of subject matters, but the national parliament didn't approve any frame law. It continued to legislate on all of the matters, and very often on these shared matters, it is legislated in details. It didn't try to distinguish between principles, fundamental principles, competence of the state, and details, competences of it. It didn't try. And the Constitutional Court was compelled to resolve single controversies. But every day, this is one of the reasons for which the contenzioso, the litigation before the Constitutional Court knew a very high increasing after the reform, essentially after 2005, when I was no more a judge on the court. After, in the past, the 80% of the controversies before the Constitutional Court was controversies about the judicial review of legislation deriving from initiatives of a single judge, the incidental system, we say. In a judge, if the judge thinks that he had to apply a law which is doubtfully on the point of view of its constitutionality, the judge must apply the Constitutional Court. Then 80%, maybe more than 80% of the controversies were incidental controversies about law, central law or regional law, but mostly central laws. After the reform of 2001, after according in the first decade of the new century, the number of controversies before the Constitutional Court deriving from controversies between central state and regions, then we give the name the giudizio via principale, that is controversies
taken by regions against the state and by
regions against state, on the state against region directly, not in occasion of the application of the law in a judicial process, but directly after the publication of a law of a state law, the region can appeal.
In other words, it was an abstract review.
After the review, yes, and
not preventive, but abstract.
With a term, of course, after 60 days, and the state could appeal against regional laws. But in the system before the reform of 2001, the regions could appeal against the state laws in a term of 60 days. As for the regional laws, they, after they had been approved by the regional council, they had to obtain the visa, I don't know, of the government committee. The government commissioner in the single regions, and if the commissioner could could send back the law to the regional council. If the regional council approved another time, then the government could apply to the constitutional court against the regional law. But this could, it was a system, of course, in the phase between the first approbation of the law by the regional council and the second approbation and the eventual appeal of the central government. There is a possibility of discussions of courts. A region could prefer not to confirm the first text of the law, to change something, and so. It was not the case for the central laws, because the region could only appeal, and they made many appeals, but not so. After with the reform of 2001, also this system was changed. Regional laws approved by the regional councils had no more to have the visa of the government commissioner. The central government can only appeal directly to the Constitutional Court in a short term, 60 days. And regions can appeal against central laws. Then the number of controversies, of course, increased very much. There was no more possibility to discuss. Now, of course, there is also still the possibility that after the appeal to the court, there is a discussion between central government and regional government. They can they can negotiate, and so the region sometimes approves a new law which modifies the precedent law, and so va incontro.
So the case in front of the court is dropped, is extended.
Yes. There are a certain number of these decisions of the court that the case is dropped. When before the application of the law has been changed by the regional council. But it is not a formalized system of negotiation. There is a political question to negotiate, to not negotiate, to obtain or to not obtain from. Sometimes if the regional council is the majority of the regional council is the same political color of the majority, the central majority, maybe they can obtain something more and they don't appeal against the central laws, and if the regional majority is a different political color of the central majority, maybe the regions appeal more frequently to the. But in general, we have to say that the contenzioso, the litigation before the Constitutional Court increased more and more. I don't think essentially because there was this new system without the possibility of rinviare, non mi ricordo più come si dice, rinviare. No more the possibility to send back the regional law before their promulgation. This is certainly one of the reasons of the increasing of the litigation before the Constitutional Court, but it is not the principal reason of this. The increasing was very, very, very high. When I was in the court, until the first years of the new century, the majority of litigation before the Constitutional Court was about the incidental system. Judges, which after the large majority of the litigation became litigation between state and regions, with the appeals directly from a region to against the state law, or vice versa, appeal of the central government against regional, so the large majority. Well, then one can say that one of the reasons, certainly one of the reasons of this increase in litigation is due to the abolition of the precedent system, where there was the possibility that the region adopted a new deliberation about the law after io non mi ricordo mai questo rinvio, come si dice, after sending back the law by the government commissioner. But it is one of the reasons, but not the principal reason of the increasing of litigation. Not the principal, I think. The principal are the fact that the new constitutional system defined a system of sharing competencies, or distribution of the competency between states and regions, based on lists of matters. Of course, a list of matters is a list of words. We say territorial government, we say protection of the environment, we say, I don't know. And so these are words. It is not so evident the interpretation that these words have to have in order to establish if a single object, a single issue pertains to one or to another of these matters, or pertains to two matters in the same time, and then there is a mixed competence, and so on. It is not so easy. It is not essentially, not only a judicial question. It is more a political question, because you can adopt a conception, an idea of, I don't know, environmental protection that is very large, or a conception more restricted. I make some example. In the jurisprudence of the Constitutional Court after the reform, the court had very often to manage to be confronted with controversies about the fact that a central law, because the Parliament continued to make laws in all matters. Then the court was called to say that if these laws were or not justified by one of the matters of the list of central competencies or not. Or some of these matters in the list are very, I don't know, flexible. For instance, three examples. Environmental protection. In the reform, it is provided that environmental protection is a competence of the state. One of in this issue, the reform was not very regionalizing. Maybe irreasonable, not so reasonable, because the environment is strictly tied to the territory, and then it is almost impossible to exclude the intervention of a region about its own territory and the environment in its own territory. But the state interpreted this clause as a clause that permitted to the state to make everything without any limits. And the Constitutional Court often had to be confronted with this problem. It is really true that regions had no more any competence in the environmental protection. And the court said that no, it is not so, because the matter government of the territorial government, that is a matter of shared competencies, includes necessarily something concerning the environmental protection. And so it is a question of sharing and of also of seeking for intese, accordi, agreements between. So very often the court said, well, this law, this law, the central law, is in a matter included in the list of the central matters, but because it incided, it refers also to matters which are of regional competences. It is necessary that there are agreements. The system of we say intese, system of agreement imposed by the law. Some decision, yes, some decision. Well, this is other example. Among the central exclusive competence of the state, we have ordinamento civile, civil, legal law, legal private order, legal civil order, I don't know, ordinamento civile. That is the contracts, property.
The matters covered by the civil code.
Contracts and so on, yes. Traditionally, it was a matter of the state, and in the new reform, ordinamento civile is a matter exclusive of the state. But this competence had been interpreted in a very, very large sense. For instance, the regulation of the labor relation, public labor, is considered a question of civil law, because the public employees are considered under the a substantially private system of relations. And then the state could and can make laws about the public employment in the regions, in any particular. Or the state has exclusive competency in in protection of competition. Well, in the name of the protection of the competition, the state made many laws, and the court approved many central laws which govern any particular matter of economy, production, industrial production,
Even the hours of opening shops.
commerce, opening hours of the shops and so on, in the name of the protection of the competition. But this clause, protection of competition as an exclusive competence of the state, was enormously enlarged. And so, more, coordinamento della finanza pubblica, coordination of the public finance, is another shared competence according to the Constitution. But the interpretation of the Parliament was that in name of the coordination of the public finance, the state could regulate in a very detailed manner all the expenses of the regions. The first time the court said, well, you can regulate the expenses of the regions also in their total amount, because the region have to observe the limits of the public finance in general, the public debt and so on. But after also the court said that yes, the central law can modify or regulate also these expenses of the regions. Then special issues of regional expenses. And so this, we name these transversal competencies of the state. That is, under the name of competition or coordination of public finance or civil legal system, the state practically makes laws on every issue, every subject. It thinks it is important to have a uniform legislation in all the state. And then the competences, the apparently very large competences of a region are very, very restricted. A last thing I have to say. The jurisprudence, and I apologize newly because my exposition is very, very bad, but the Constitutional Court in the first decades of its activity was confronted very strictly with regional questions, because there were not the ordinary regions. There were only the 5 special regions. After the reform of 2001, the court was confronted with a constitution that apparently gave to the region enormous new competencies. And the legislation of the state continued to, as if the constitution were not changed, continued to legislate, to rule every matter in the name of these transversal competencies of the state, or in the name of a necessity of largest uniformity. And so the Constitutional Court was confronted with an attitude of the central organ very, very against the region. And the Constitutional Court was not so. In general, speaking generally, the jurisprudence of the Constitutional Court was and is more inclined to support the central legislation, and to restrict the competences of the region. Even also because the economic crisis made that the finance of the region was under contestation. It was a difficult, all regions and difficult, and above all, because the financial system was and is very, very centralized. The Constitution provides that the region have to have a fiscal autonomy, there are taxes and so on. But until now, the finance of the regions is almost totally dependent from central decision of the state. That is, there is no financial autonomy. In the 2009 was made a delegation law about the fiscal federalism. But that law had no application, practical application. Then a new constitution, very regionalizing. An traditional attitude of the central government and the parliament, very centralizing. An attitude of the Constitutional Court more inclined to support the ideas of the central government. And so the result is that the regional autonomy in Italy now, in this moment, is perhaps sometimes more restricted than before the reform of 2001. And the last thing maybe has to be said that the composition of the Constitutional Court, the Constitutional Court have 15 judges. 5 of them are elected by the magistrates of the High Courts, Court of Cassation, Court of Accounts, and Conseil d'État, State Council, and the attitude, generally speaking, attitude of the magistrates, traditional, is not so favorable to autonomy. 5 of them are named by the President of the Republic and 5 elected by the Parliament, of course, according to the indication of the parties. And so they have often a political sensibility, but not necessarily an attitude more favorable to the regions. We have to say that traditionally the jurists in Italy are of centralizing tendencies. The school of right in Italy, the school of law in Italy, the traditional school of law, they are very inclined to support a centralized system. For instance, until very recent years, the totality of the constitutional judges who were professors of constitutional law came from constitutional, I don't know, by schools in the south of Italy, Naples, Sicily. There are very important schools, and their sensibility was essentially on the central exigencies. I was the first judge in the history of the Constitutional Court who came from a northern town in Italy, from Milan. The first time I was named in 1996, after the court was functioning for 40 years. I was the first one who came from a northern region, from Milan. It is, of course, we say, and the second from the Lombardy. Now the things are changing.
Even too much.
Maybe, well, I don't know too much, but well, but in very, very recent times, 1, 2, 3, 4 years. Yeah. Now we have 4 judges of Constitutional Court who were professors in Northern University, Milan, and Padua, Turin, and so. And there is maybe one of them came from Trento. One comes. It was the ancient rector.
The former rector.
The former rector of the University of Trento. And so, about as for the composition of the court, maybe things are changing, but are changing in these last years. I don't know if I'm not a sociologist, but I don't know if this question has a weight in the. I think yes. I think that in the history of the jurisprudence, it is something that has an influence. Not, of course, not the only thing that has any, but also this has an influence. Where do the judges come from? I stop here. Excuse me for the confusion.
No, thank you very much. Thank you very much. Also because of your effort in making your presentation in English, let me just point out 2 things about your presentation. The first is there is no formalized stage of negotiation between regions and the central government. In other words, there is no formalized way of avoiding going to court. At the same time, going to court before the reform of 2001 and after the reform of 2001 does take place, although in a very, shall we say, non-transparent way, where also party politics may have its role. The second thing which I think is important to point out is that in some cases it is the very case law of the Constitutional Court which encourages regions and the central government to reach an agreement. And there have been cases in which a law or a decree has been declared invalid precisely because there had been no agreement, which means no negotiations, before the central law was enacted. So in other words, there is some role, but it's very marginal, very non-formal, unless, of course, it is legislation which says that on one particular topic an agreement must be reached. So I would say, and third, if you like, there's no general principle in Italy encouraging to find an extrajudicial settlement, very much to the contrary of what we have seen in Switzerland, South Africa, Belgium, and Spain. And in particular, it is now on Spain that Maribel González Pascual is going to talk. Now, let me just say that in order to give Maribel the proper time, I would like to delay for perhaps 10, 15 minutes the coffee break. So you know you can rely on 30 minutes. All right? Thank you very much.
No.
No.
No. So I have.
Okay. Tutto, sì.
Spaniards tend to talk very quick, and that's a problem if you are talking in another language. For the audience, particularly. This is a very not so many. Okay, so what I'm going to focus on litigation out of court. So I'm going to focus on the cases in which there has been an agreement or they have tried. So I'm going to talk first about the context in which the reform was approved, the amendment of the Organic Act of the Constitutional Court. Afterwards, I will deal with the procedure, which is quite easy, quite simple. It's not very formalized. Then with the scope and the follow-up of the agreement, when it has been reached. Then with the prices. And afterwards, I will deal briefly with how this settlement out of the court is being affected, but how actually the regional state works out. And finally, I would make the concluding remarks. Let me thank you, Roberto, again, for trusting me. It's been quite a challenge to keep up with my academic career, but as I try. And in this case, this is a very important issue currently in Spain. And actually, this is a colleague from mine that has come also, because for the ministry is very important, this issue. Okay, the contents. The amendment of the Organic Act of the Constitutional Court was approved, in 2000. The new article 33.2 to allow the settlement of conflict of powers between regions and the states out of court. The amendment was approved as a response to the increasing cases before the court, the Constitutional Court. In fact, it will look into the parliamentary debate concerning the amendment. The government, the central government, stressed out that at that very moment there were 199 cases before the Constitutional Court related to the conflict of powers. That the court was completely overwhelmed by the cases and that it was delivering judgment with 9 years delay. Actually, we have to say that there was also many cases regarding individual complaints. It was overwhelmed by both cases. So this amendment was inspired by the Cooperation Commission that was foreseen in the Autonomy of Statute of Navarra, that has achieved a reduction of 50% of the conflicts between the region and the states. Besides these numbers of how many conflicts there were, we have also to take into account that in 1999, so 1 year before, the main act regarding the Public Administration Act had been amended precisely to improve the cooperation between the central government and the regional governments. So this trend of increasing cooperation between the central state and the regions took place during a trend in which the central government needed the support of the nationalist parties in the lower chamber. That was when this was approved. The procedure is a quite easy one. It's voluntarily. The article is very clear. Both administrations can have to accept it. The Basque Country was reluctant to it during several years, but normally it's very, very, very uncommon that one of them refuses, because at the very end you get more time to challenge the act, and lawyers always want more time. So it's voluntarily. The deadline is an essential element, because the deadline of an action of unconstitutionality is of 3 months in Spain, and in this case it is extended to 9 months. The existence of a deadline for the action of unconstitutionality is extremely relevant, because the players know that there won't be further chances to challenge the act. We have also to consider that the central government must ask of the Council of the States a report before challenging any regional acts before Constitutional Court, which means that the actual deadline is of 8 months, given that the Council of State is an advisory council in Spain, but it has an undeniable authority. Thus, if the Council of State considers that the act should be challenged, the government will do it. That is why the agreement should be reached in no more than 8 months. Once the report is out, this is what the report says. Regarding the bilateral commission, it's a political commission. The president of the commission must have ministerial level. This procedure fosters the bilateral commissions in Spain, and nowadays every region has foreseen a bilateral region, and they have become really important, not only in this field. They were further instigated actually by the reforms of the Statutes of Autonomy. Since 2006 there have been several. Even seven Statutes of Autonomy had created a specific bilateral commission for financial and economic affairs. They have both, the general and the one on economic affairs. The commissions delegate the big share of the hard work on working groups, which are the ones really dealing with the details. They tend to be permanent. There is one permanent in the Ministry of Regional Policies, which makes them quite powerful. Last but not least, the ministry affected by the challenge, the one responsible on the subject, is consulted by the working group, and the report is decisive, I would say. It has to agree on the decision. Regarding the scope of the agreement, the procedure is thought to avoid a constitutional challenge to annul with the force of law only those acts approved either by a region or by the state. This implies several problems or issues. First, the ones negotiating are the governments, but the object of the challenge might be an act approved by the parliament. May an executive decide on a decision made by a parliament? That's, we all know, it's a traditional criticism towards cooperation, that governments might try to replace the parliaments behind doors, but still governments negotiate within the frame of their powers. That's, if the agreement foresees the amendment of the act passed by a parliament, the government may only commit to table the bill before the parliament. This agreement was more than enough in Spain when the governments were supported by the majority of the chamber, because the president of the region or the president of the state was the head of the political party at the regional or at the national level in a two-party system. Things have deeply changed in Spain, as we all know, and there will be actually regional elections next Sunday, and we will see how many presidents have the majority of the chamber. According to the polls, I don't know if there will be one of two, no more. So this is becoming trickier, this agreement. Then the second point is acts of the state in a bilateral commission. In certain cases, there actually has been a multilateral negotiation because several regions wanted to challenge the same act of the state. So there were several bilateral commissions, but the agreement offer was a similar one. Still, it's logical to consider that the acts approved by the state should be discussed in a multilateral forum, preferably before its approval. That could be the logical way to do it. But if it's not, they had made this kind of multilateral negotiation. Regarding the content of the agreement, reviewing then, one would be no challenge without any requirement. I have no final case. Legislative amendment, the typical one, which leads to the formal question of an executive deciding on this. Or the third is an interpretative agreement. Agreement regarding the application of the acts or regarding the further development by a ruling of the government. Which it comes to the follow-ups, the commitment has to be clear with a clear deadline. So at the beginning it was not so clear, but now there's always a deadline. If the agreement concerns the amendment of an act with force of law, the follow-up is kind of tricky because which procedure should be followed to call for compliance with the agreement. Actually, this has been quite discussed, and the government tries to ask that the bill has to be tabled before the deadline of the challenge comes to an end. So that's kind of will of the other part that really wants to comply with. It is easier, it is the interpretation or the development of the act, the content of the agreement, because eventually it could be challenged before an administrative court. But in any case, the best guarantee of the compliance is the need of mutual trust among parties that will have to negotiate further in a near future. The no-compliance would break the trust, could impair the essential cooperation between the states and the regions in many fields, and regions and states want to be reliable, or they should want to be reliable. That's all. Okay. When it comes to the prices, which has been the role of the Constitutional Court? Agreements are based on the case law, quite specific and technical, most of them. Most of the cases are related to rules on technical matters. That's important as they might be. They are supposed not to be particularly controversial. The Spanish allocation of powers might be described as an extreme detailed list of competences, containing a constitution whose amendment is de facto almost impossible. A system dependent on courts without flexibility, in which there would be only room to discuss on technicalities. But I like to say that technicalities have become a safeguard for political players. Because allocation of powers, as we know, must allow that different political projects coexist in the same territory and that those projects change over time. So the question is whether there is room for settlement if there is a change in a political project. Actually, there is, because a new government might even instigate a withdrawal, reversing the decision of the forming agreement, and they follow the same procedure, the 33. Normally, withdrawals are really technical because they derive from a judgment, repeals, new rules, but they are withdrawals that respond to a new political project. For instance, when the current government took office, it decided to withdraw several challenges to regional acts and social entitlements, because the new government have a different view on the public role and social states. In these cases, the role of the Constitutional Court has been essential. First, the court was unofficially informed of the negotiations, and it probably delayed the judgment. We knew that it was about to deliver the judgment, so it was said to the news, there will be an agreement by the ministry herself. Second, there was a certain change in the case law, granting more room to the regions on social entitlements in cases close to the ones that were being debated on the bilateral commissions. This new case law made legally and politically easier for the bilateral commissions to get to an arrangement. We might even wonder whether the Constitutional Court considered wise to give room for the political commitment. In fact, the Constitutional Court can refuse withdrawal if there is a constitutional interest on the judgment, but it has never done it. In a nutshell, Constitutional Court probably considers that the allocation of powers has been misconceived by the political players. Then, is a successful system? Well, like here I have the data. So if we go to the data, we see here those are the appeals, and here's the agreements. The first years we might see that it wasn't very successful, but perhaps it was they needed time for a judgment, so I don't want to blame on that government. I have written which government was because we tend to think that it is successful when there is a coalition, and it is not when a political party has the majority. But that's not what the data says. It's that it has been always been successful. Even when there is a lot of cases, you see the first PPE Rajoy, there were many cases that has to do with the crisis and with the Catalan question. And actually, in the Catalan question, there was no settlement out of court. We really see that there is a ratio agreement that is increasing through time. So it's been quite successful. There is no data from the current government, the government of Pedro Sanchez, because the report is being drafted as we speak. There's no report yet, so that's why I did not include it. Here I only have the cases in which the Commission is summoned. But there are cases in which the agreement is even easier. For instance, during the 12th term, from July 2016 till June 2018, the ministry has sent 97 letters to the region, warning that the act wouldn't be challenged, but recommending a more or less a specific development of the act, like I won't challenge the act, but I will look carefully into the development of the act because it seems problematic. Actually, I have to say that the only criticism that you might find is that the Article 33 might also become, or probably it has become, an unofficial system of follow-up of the regional development of implementation of the rules approved by the states. Since there is not a system in place to formally watch over the regional legal acts that develop of art, the acts approved by the state, the procedure to allow for a settlement out of court might have this secondary goal. Because in fact, the state follows up each and every bill tabled before the regional chambers by the regional government, and each and every decision eventually passed by the chamber, by this commission. Then we have the impact of the malfunctioning of the state of autonomies. There is a scarce, how this influence on the system, there is a scarce cooperation. It is not uncommon that quite similar regional acts are discussed in parallel bilateral commissions. We might find that there are many regions approving very, very similar rules, and they all are being discussed, which proves that it's been heavily discussed at the regional level, the competence of the states on the matter. It is also common that an act of the state is challenged by several regions on similar grounds. This proves, in my view, the lack of horizontal cooperation. There's non-agreement among them. Each one discusses in a bilateral commission is discussing the same regional act. And there's a very poor vertical cooperation that proves why this is happening now. Now we have many cases on local police, and the acts are the same at the regional level. A misleading understanding of the allocation of powers, the lack of political arrangements, the mistrust even among even antagonist actors has led to a theoretical separation of powers in Spain that relies on the legal fiction that powers can be clearly separated by a court, as if the Constitution and the regional statutes had foreseen each and every detail of the separation of powers, and also as if the meaning of those provisions were plain. Law has pretended to replace policies, and the outcome has been the prominence of the constitutional courts, a development that eventually damaged the court itself. Still, the approval of the Article 33.2 of the Constitutional Court Organic Act and the deference of the Constitutional Court towards is an implicit acceptance that the allocation of powers sorely needs political arrangements, and the main players seem to know it. Depending on political will, cooperation always requires political will. Still, the cooperation in this field has never been controversial. Quite on the contrary, according to the data. These are not the data when it comes to cooperation in Spain. Only in EU matters. It's successful, the cooperation, and in this field. It has been criticized recently. Article 33 has never been a controversial issue until last year, where it was questioned even by the deputies. There were 2 questions in the plenum, like this settlement of the court is putting into question the unity of Spain. But the development has much to do with the Catalan crisis. There were that the government was negotiating with Catalonia, not only, but the point of the question was that, and a case related to Basque Country. The Catalan crisis is touching everything that has to be with regional states in Spain, and the debate on the regional state has become deeply tense, rough sometimes, and generally deeply unsound. So even this procedure has been questioned, but I would say most people was not aware of it. See, if we come to a conclusion, more or less, yeah. I would say that it's a successful procedure in the frame of travel regional states, extremely dependent on courts. In the frame of a scarce and crippled system of cooperation, it works quite well. And surprisingly, in the frame of the Catalan crisis, the Article 33.2 of the Spanish Constitutional Court Act, so this procedure, was one of the most important tools when the new government took office and tried to reach out to the Catalan authorities as a first step to regain the mutual trust. Actually, one of the first decisions was to summon the bilateral commission to reach several agreements, and the only feasible factual agreement that we really reached was that they would review the challenges before the Constitutional Court, that the working groups would work on it, and there were withdrawals. So that was the first clear offer from the government. It responds to a peculiar regional state, to say the least. It is a bilateral system, which has been criticized in Spain, but I think that the fact that it's bilateral is in line with the asymmetries that characterize the Spanish regional states, in which strong regional identities are constitutionally protected. So that seems very wise that in many cases it has to be a bilateral decision. It is also a consequence of the anomalies of the Spanish regionalists, a misleading interpretation of the allocation of powers that has led to this terrible amount of cases before the Constitutional Court, null or zero participation of the regions in the main decisions of the state. So in my view, it's quite problematic that are the the legge cornice, the Rahmengesetzgebung, the ones that many times are being questioned in these commissions. That should be dealt with in the Spanish parliament, or there's in the sectoral conferences. In principle, whenever the state has a new proposal for an act, in the conference on the matter have to discuss this proposal with the regions. But again, the sectoral conference does not work out so well as this system. And in many cases, it depends on the ministry, it depends on the time. They are not always summoned, they don't always come. So does not work out properly as filling the gap of the lack of a chamber in which they really cooperate. And then we have a scarce and fluctuating cooperation. So it's very, very, very scarce, and it's changed a lot. And the lack of horizontal cooperation, it is also a problem. Not only we see it in my view, regions were able to agree on the content of the ads and talk to each other, they will have a leverage before the state. But they go one by one negotiating, which is easier for the central government, but it's not the way to deal with it. So that is, I have to say that has been a headache, and these cases in the Secretary of State. But this is, so to say, within our travel status, we are very satisfied with this development. So, thank you very much.
We all thank you, Maribel, for this very well-structured presentation with many data and in particular because of your optimistic final words. So it...
It's my nature. I am optimist.
All right. All right. In spite of the fact that you very correctly define Spain, the troubled state of the autonomies, which of course is quite appropriate. Of course, we are not going to start a debate now. I just have one question which may receive a very quick answer. You said there have been questions in Parliament about the issue. You didn't tell us anything about the answer. Was the answer, I suppose, by the Ministry or by the Presidencia del Gobierno still supporting the practice?
Yes, yes, yes.
Oh, it was so.
It was, yes.
So even in the parliamentary debate, the practice was supported.
Yes, yes. Actually, there were two. The one of the Basque Country, the answer was quite technical. The one given by the ministry, and the second one, it was a nice one because the second one, the one asking was Popular Party. So we came with all the data, but see what you have done. I mean, all the governments have done it, so you are trying to make this a controversy now because it's the Catalan government. But, so in both cases it was defended. As you see how many cases we have. We have to do something.
So that's important. Also, I would like to point out the fact that you also referred, following what Chopper wrote 40 years ago, that the political safeguards of regionalism could work better, and in particular could improve the multilateral impact of this kind of approach, rather than having each comunidad autónoma separately deal with the government, in particular when when the regional legislation is very similar, or when the objection to national legislation is very similar. Perhaps some what you call horizontal cooperation might be useful, but that of course is perhaps one step forward in order to improve the quality of the whole system.
They try it. When the new statutes of autonomy were approved, they make the conference on the governments of the regions. But the one that was fostering everything was Catalonia, the which is a pity. Catalonia has always fostered the multilateral system. So it was really improving the system. But then the crisis exploded and Catalonia did not want to take part of it. Basque Country was at the beginning out of the system. And in my view, does not make sense without them.
Anyway, this is another very important issue in general, also besides what we're focusing here today, bilateralism or multilateralism in the relationship between decentralized units of government or centralized units of government, in particular when you have 15 or more different regions and the like. All right, well, thank you very much. We can declare achieved our first part, our first session, in which Italy and Spain have been analyzed. So we deserve now some coffee, tea, or whatever. We may go outside this door. It is we have to go over the stairs, and then on the left there will be a room that where we can have a coffee and I suppose some refreshments. And we'll meet here in 20 minutes. Thank you. So that we have sufficient time. All right, I think the time has come that we start the second part of the morning session. Just for the record, the table will be without any participants because also Professor Belzer has her own slides to show. So if, because we are on internet, and so if viewers of the seminar see that the chair here is completely empty, it's not because you're not speaking to anybody, but because we all want to take most profit of your presentation, and therefore we'll sit there in order to see your slides. So it is a pleasure to give the floor now to Professor Eva Maria Belzer, who will tell us something about the always interesting experience of Switzerland. Please.
Good morning, everyone. Thank you, Roberto, for organizing this interesting event and for inviting me. It is always a great pleasure to be in Trento and to meet you. I have decided to present my paper under the title of Let's Talk because it's such a famous saying in my country. Whenever there is a federal dispute, the slogan would be, one, we have to talk to each other, one has to talk to each other, or let's talk. So when I was preparing this presentation, I was trying to find out where the slogan comes from, because it's often used in newspapers, let's talk. So I found that it really comes from this movie produced during the war, when the Swiss government financed that program of cultural defense against the neighboring countries, strongly emphasizing the particularities of Swiss identity. And the movie title really was, One Has to Talk to Each Other. And that's what the film is all about. And I think it's the quote we still use. And we really use it all the time, even when we talk about Spain, newspapers and journalists would wonder, why do they not talk to each other? That's what federal partners are supposed to do. And it's still very much the way the Swiss government would present itself. When everyone was saying that the Federal Council was going through a crisis, was exposed to difficult negotiations about the banking secrecy, that was the message of the official photograph. At least we still talk to each other, so it can't be that bad. If it would have been much more difficult for me to answer to Roberto's call when the topic would have been solving federal conflicts in court, because we usually do that outside of courts. So I'm not on the right slide. Seen from the outside, the Swiss system looks quite normal. our Federal Supreme Court has that typical competence to solve all conflicts opposing the Confederation and the cantons or the cantons. It has not always existed, and we will come back to that, but since 1874, second federal constitution, the Federal Supreme Court does have that mandate, and since the last total revision of the Constitution, that competence of the Federal Supreme Court is there. So seen from the outside, we look like a normal federal state. The Federal Supreme Court here disputes concerning violations of federal law, international law, and para 2, it hears disputes between the Confederation and cantons or between cantons. So we have that normal arbiter or umpire, most federal scholars would say a system needs. But we don't use it. We don't use it. I was looking back for the last 70 years, and there were only 7 cases opposing the Confederation and the cantons. So 1 every 10 years. We have slightly more appeals, where the Federal Supreme Court is not the only instance, but the body of appeal. We have slightly more cases opposing cantons, but still very few. Just to show you the 7 cases we've had, one was in 1955. It was a conflict about regulation of airports and air traffic. One 22 years later, still about opposing the canton of Geneva and the federal government. It was on nuclear power plants, whether a nuclear power plant approved by the federal government would still be in need of cantonal and municipal approval. It's the only case a canton actually won in Lausanne. These nuclear power plants need approval by all the 3 tiers of the government. Then 1980, St. Gallen on food policing, a negative competence conflict, where the Confederation and the cantons did not want to do the food policing of imported goods. And then a case in 1999 about regulation in the field of gambling, where the canton of St. Gallen had strong economic interest. And then 3 cases where the Confederation was suing one of the cantons, twice cases from Basel. It was once about the federal civil code that Basel tried to complement with its own legislation, and twice about data protection, basically. And that's all we have. That's the 7 cases that we were able to come up for the last 70 years. We have a few more cases opposing cantons, but since this is not the topic of our seminar, if you allow me, I will skip this. So why do we just wave at each other and don't take each other to court? That's what I want to try to answer for the remaining time I have. And I think we have to go back to the confederal origins of Switzerland. 1481 was probably the deepest crisis the loose confederal system of Switzerland had. It was triggered by a severe conflict about the distribution of spoils after the Burgundy Wars, and also the application of the cantons of Solothurn and Fribourg to the Confederation. The cantons could not agree on that issue, and most observers, internal and observers, outsiders observing the situation, believed that the Confederation would fall apart. It was at that moment that a pastor went to see Niklaus von Frier, a hermit, living in a small chapel in one of the rural parts of Switzerland. So he had the role of a mediator. He would also at that time advise foreign leaders, European leaders. And he came up with an idea that was carried back to the Confederal Diet. And after 2 hours of discussion, the matter was solved through a compromise. The two cantons were allowed to accede the Confederation, but had to give up some of the privileges of cities. So, and I think it was an event that deeply marked Swiss national identity, because in the Federal Palace you see two statues, and one of them is Niklaus von Flüe with his hands like this, one, keep calm, don't use violence, and listen to each other and talk. It's still today considered to be the national hero, and in disputes we would also always, politicians would frequently refer to his advice of the 15th century. So the Confederal Diet functioned very much based on mediation. That also had to do with the fact that there was no other mechanism. For hundreds of years, the Confederal Diet were like an international organization. Every canton would send one delegate, and that would be the only body the Confederation would have. Was forced to find solutions through negotiation, mediation, famously through disputation, because that was the second or the next severe crisis of the Confederation, of religious conflicts, which were tackled by disputation, that the Confederal Diet would invite to a public discussion, a panel, 200 delegates, 100 being Protestants, 100 being Catholics, and then they would fight. And the protocol of the discussion would then be published. And I think we still often come back to this Badener disputation, because shortly after this happened, two leaders that you would see in the back were planning to fight on religious issues, and the soldiers and peasants would just decide to have a soup together on the border. So it's this not really historic event, but the narrative saying that disputation is the system fitting our democratic, direct democratic system. You have to talk to people and convince people, and even if leaders in the back want to fight, the population generally doesn't want to. And obviously that is the way that is very closely linked to Swiss forms of decision-making through popular votes. It is about disputation. It's often, if there is conflict, based on parity. Most of these popular assemblies were not based on any separation of power. They would do everything a government has to do, lawmaking, application, and dispute adjudication. So they would have judicial bodies elected out of the body, and it would be parity of the two sides, and they would operate like an arbitration body. So that still exists as a system of dispute resolution on all the three tiers of government. So when we now look at the history of the federal state in 1984, no one saw a need to have a federal Supreme Court. It was established, but it was only competent basically for criminal and civil law matters. It was no permanent court. It was not an independent court. If there was a dispute, the parliament just would elect among its members a body solving the issue. And all the real conflicts, constitutional conflicts, were solved by the Federal Assembly, Parliament, bicameral Parliament, and the Federal Council, itself a collegial body. in 1874, things slowly started to change. The Federal Supreme Court now became a permanent body with its seat in Lausanne, and it started to have a mandate to solve conflicts about competences. But there was still a long list of exceptions of political questions that would still be solved and decided by the Federal Assembly. So, while the Federal Supreme Court gained in power and influence, an unwritten constitutional principle really did the job of solving conflicts. It was the duty to respect the principle of solidarity, the duty to act in good faith, and the principle that is very well known in a number of countries, including Germany, of federal loyalty. It's an unwritten constitutional principle considered to be binding on all federal and cantonal institutions, be it a parliament, a government, or any other official body. From this comes this saying that we have presidential system, parliamentary system, the Swiss is a dialogue system. It's almost a system of government on its own because it's based on talking to each other. Then comes the total revision of the Constitution decided in 1990, entering into force in 2000. Now the Federal Supreme Court is further strengthened. It now has a general mandate to solve not only conflicts linked to competences, but to any conflict opposing federal and cantonal institutions. And in parallel, we see a limitation of the competences of the Federal Parliament and the Federal Council in the field of conflict resolution. At the same time, some of the unwritten federal principles are now being codified, and that brings us to the general principle that Roberto has read to us earlier this morning. Many observers consider this to be a tremendous change in the system, not really for the Swiss. It was a norm that was just writing down what was happening anyhow. This is not a norm that would be quoted in court. It hasn't had any constitutional engineering power because it put in writing what has been the practice for centuries. So what scholars would write about it would be that it has 3 layers. It's programming, it's a binding program on the constitution maker and on federal parliament. It has a framing power, so it's a guiding directive for interpretation, and most scholars would say that it's also justiciable. So it could be taken to the court and enforced by the court, but so far we have not seen this happening. So in brief, we would say what Article 44 codifies is a duty to talk. It's a duty to negotiate, duty to have direct talks between the conflicting parties, and it's a duty to mediate, which is to include a third party helping the negotiations. If that fails, you can still go to court. That's the direct lawsuit I mentioned at the beginning, where we only had 7 cases so far. Most scholars would agree that going through negotiations and mediation first is not a formal requirement to access the Federal Supreme Court. You could do that directly. Probably not an issue because we all know that neither of the partners would do that. So why do we not have cases? And I think one of the main reasons, in addition to history, is a legal one. It's not very helpful to go to the court for a canton because there is limited constitutional review. An act approved by the Federal Assembly, so any federal legislation, cannot be challenged in the Federal Supreme Court. So there is no abstract review. You cannot attack a legislation approved by both chambers of parliament and the people. You can go for concrete review, where if the decision is based on a federal act, the Federal Supreme Court is bound to apply the federal act. You cannot really see it from Article 90, but what it really says is the Federal Supreme Court and the other judicial authorities apply the federal acts, even if it should violate the Constitution. So that is the famous limitation of constitutional review. Obviously, that is one of the important reasons why a canton would not challenge federal legislation the way we have just heard that happening in Italy, because it won't help. I was trying to look at the cases where real mediation has taken place. And I have found two recent situations where these alternative mechanisms have been used in a very formalized way. One was the conflict about cultural artifacts, where opposing two cantons, Zurich and St. Gallen. Apparently, Zurich had stolen some artifacts from Zurich as late as in the 18th century. And in 1996, all of a sudden, a conflict pops up about the return of these artifacts. The two cantons cannot agree, but they agree on negotiations mediated by the Federal Council, and that happened for 2 years. They, in 2004, signed the treaty, more or less codifying a compromise that some goods were returned, others were kept in Zurich. The other more famous case of a mediation was this one. Two flags of two cantons in the middle, the mediator, the federal government. This was about the conflict opposing the canton of Jura and Bern, when famously the new canton of Jura was created in 1979 after a number of referenda in the regions. The separatists of Jura were not very happy about the outcome because only 3 districts decided to become part of the new canton of Jura. 4 other French-speaking districts decided to remain with Bern. You can see from the flag that this did not satisfy the Jurassic people because these lines stand for the districts, saying the message is we have 3, but we also want the other 4. So the conflict was lingering on until it escalated, and in 2004 there was an agreement to create an inter-Jurassic assembly based on an agreement between the 2 cantons and the Confederation. It was a forum for dialogue, it produced studies, it adopted a final report which obliged both cantons to have referenda, to bring back the territorial question to the people. In 2013, these referenda take place. It's a yes in the canton of Jura, we want to include the other 4 districts. It's a no in the Bernese district. According to the final report, 4 years later, there are referenda on the lower level. Municipalities sitting at the borders can decide whether they want to join French-speaking Jura. Bellapron says no, Sauvigny yes, in Moutier yes, but as you might have heard in 2018, this vote of Mucci about the changing of borders is invalidated by the Bernese government for violation of political rights. I can tell you more about it if you're interested. So why do these systems work? Why is the Federal Supreme Court not used as a body to solve conflicts? I think Maribel has mentioned coalition government. I think it plays a role in our country as well. We have collegial governments used to negotiations and broad agreements on all the tiers. We have also broad representation of political parties in parliament. We are based as a system of consensus democracy. No one is taking hard decisions. You always talk first. There are constitutional obligations of reciprocal information, very formalized procedures of consultation. No law is being adopted without long formalized procedures of consultation, participation, and direct democracy. I think that is working very strongly as a preventive device, because most referenda are initiated by the people. 50,000 citizens can do so, but 8 cantons can do the same. So if a number of cantons express concerns about the law, federal law, it will not be adopted the way it is, because the cantons can always threaten to go for a referendum. They have only done it once, but they have threatened it very frequently, and when they used it, it was extremely successful. So they have a very strong bargaining power. I think we still have leftovers of political conflict resolution. The federal parliament has a constitutional mandate to ensure the maintenance of good relations between the confederation and the cantons. It is also the body guaranteeing, so approving cantonal constitutions. That still doesn't go to the Federal Supreme Court. So finally, we have a lot of informal mechanisms, extra constitutional mechanisms, and I think the first would be we have very strong intercantonal cooperation. So when Maribel was saying it's bilateral in Spain, it's multilateral in Switzerland. Cantons have started to confront the federal government together in formalized concordats or in intercantonal conferences, many of them including all the 26 governments. And it's quite an unwritten law that nothing happens without the agreement of the conference. These conferences all are reunited together in a prestigious building in the capital of Bern. It's called the House of the Cantons, and it has started to operate a bit like a third chamber of parliament. If a law has gone through both parliaments, it will go to the House of Cantons, and if the cantons give a niet, that's the end of the draft. I think it also has to do with an issue we've heard on Italy. Cantons are powerful actors when it comes to financing government acts. They have a say because they are financially strong actors. I'll come to my last slide because I think that I'm running out of time. Why do we solve issues out of court? I think it has to do with the long history of doing it that way, and some confederal leftovers. Still a very low acceptance of the idea that a court can legitimately solve a political constitutional matter. We have a limited role of the judiciary. We've had this initiative against foreign judges, as you probably have heard, the popular initiative on self-determination. But it really was also an initiative against our own judges. We don't really believe in judicial conflict resolution in constitutional matters. It's shocking for me to say so as a constitutional lawyer, but it's a fact. But we have elaborate mechanisms of solving issues outside of courts. I think in many ways, and I think that has been a conclusion during the morning, that can be more effective and sometimes even more legitimate. What we have, and what probably is missing in Spain or doesn't exist in the same way, a very strong solidarity amongst the cantons. If the canton Ticino, the only Italian-speaking canton, is against a national legislation, it will not be left on its own. Others will use their shoulders to push the Ticino or French-speaking agenda through in Bern. So there is a very strong federal spirit, even in the federal institutions. And I was wondering why that is the case. And I think it has to do also with personal careers. We don't have national politicians in the narrow sense. They all start in the cantons. Every Swiss politician would first have been a cantonal politician. He or she would always know what it means to govern a canton. And it's only after a long career on the cantonal level that you would, in a way, move up on the national tier. And most politicians would not forget about their origins, would still have very deep political links with their cantons. And I think that is an important element of that federal spirit. So that is not what I wanted to write. The country is always described as a consensus democracy, but I think we could also give it the label of a consensus federation. It is a negotiated federal system. It's a process, and it is permanently negotiated, mostly through political means. And now I see that my time is up, and I give the floor back to Roberto. Thank you very much.
Thank you very much, Eva Maria, also for respecting so accurately the time limits. As usual, your presentation has been extremely interesting. As I would say, good presentations on Switzerland always are. In fact, this is a presentation which shows to what extent what we experience today is very much the product of history. And certainly this is the case in particular with Switzerland, if nothing else, because of the continuity of the state, which is so remarkable. Let me also point out, not as a way of summary, but just of emphasizing a few points which I think are part of the comparative approach, which I care so much for, that political culture is so deeply rooted in Switzerland, the political culture centered and headed to consensus democracy and consensus federation, that there is no requirement for a formal procedure. In fact, we heard that the rules on collaboration have been codified at some stage when the total revision of the Constitution took place, but that was perhaps not necessary because the culture is already there. And also, I think it is very interesting to point out how much the referendum in this context may be seen as a deterrent. Normally the referendum is described in the experience of Switzerland as a physiological instrument of government. Whereas in this case, it might be interesting to have a history of the referendum that were threatened but were never set or organized. And that is another influence that the referendum and direct democracy can exercise in its influence of the system of government. Also, last point I would say, it is important to put in evidence, as there is no formalized one way of organizing the negotiation. This has been the case of Spain, but there are several ways, and all of them are fairly informal. So that there is a sort of formal codification of the principle, but there is no regulation on how the principle is to be enacted historically. So we are in a situation which is quite far away from the one of Spain. And also there is this idea that the judiciary, and in particular the federal judiciary, is not there to solve all political controversies. And this recalls what I mentioned about Chopper analysis this morning. And when he said the political safeguards of federalism should be sufficient, and apparently in Spain they are. So thank you very much again for the presentation. Now we have the last presentation in the morning by Julien Pierret. You also have some slides, I understand. Yeah. So we are going to move on the other side. You come to the table. Julien is the director of the Centre du droit public de l'Université libre de Bruxelles. So you're welcome to take your 30 minutes, at the end of which I hope we can have a general discussion on the 4 countries which have been dealt with this morning.
I'm sorry, I had to export my keynote file in the PowerPoint file, and I noticed that during this operation the layout and the color has changed. Really sorry, I hope it will be still possibly. I don't know how to use PowerPoint. I'm really sorry. I'm really used to it. Okay, it's good. Okay, sorry. Okay. Okay.
It's not moving here.
Okay. So, good morning, everyone. Particularly happy to be with you in Trento. I first want to warmly thank Professor Tognati for inviting me to this symposium. And I also want to thank Ms. Giorgia Sartori for the impeccable organization and the very warm welcome I have received. During many years, I used to apologize for speaking English like a French president, but since Emmanuel Macron, my joke is no longer pertinent. And I feel more than a little intimidated by the idea of practicing my rather loosey English in front of internationally renowned constitutionalists, which is certainly not my case. And for good reason, question of cooperative federalism do not fall within my scientific expertise. I must therefore thank 2 colleagues who rather are specialists in this field. First, Ms. Joanne Poirier, who most of you must know and who has worked for a long time in the research center I now have the pleasure of leading, and who was taken from us a few years ago by McGill University. Okay. And also I must thank Ms. Anne-Emmanuelle Bourgault, professor at the University of Mons, very involved in the criticism of Belgian federalism, but whose English is probably even less assured than mine. So in the 30 minutes I have been given, I will try to present to you how conflicts between the components of the Belgian federal state can be resolved without any legal or judicial proceedings. Especially in the second part of my presentation, I'm going to discuss a key body in that regard, the Consultation Committee. It's a political body which perfectly illustrates the paradox of the Belgian state. We can sum this paradox up as the following. The more important an issue is, the less precise are the rules governing it. This is a major challenge given the complexity of the Belgian institutional system in this respect, and also more generally. I will therefore begin my presentation with a brief reminder of the main characteristic of Belgian federalism. Indeed, like any federal system, Belgium has a series of very specific features. So to remain relatively brief, I will highlight 3 of them. Those features must be recalled in order to fully understand and the institutional context in which are resolved conflicts between federal authority and federated entities. So the first of these characteristics is that Belgian federalism is a young federalism, a dissociation federalism, and an evolutionary federalism. The Belgian state was born in 1830 as a unitary and French-speaking state. French was certainly a minority language, but was above all the language spoken by the country's cultural, political, and economic elites. It took almost a century before the first linguistic laws recognized the existence of Dutch as a language that could be used in administrative or judicial matters. In 1963, a linguistic border was established by law. It divided the territory into 4 linguistic regions, which are not federated entities, but which determine the numerous and complex rules governing the use of languages in Belgium. French-speaking region, Dutch-speaking region, German-speaking region, and a bilingual region located in the capital of the country, Brussels. This border opens a period that could be described as proto-federal and will continue for 40 years. Indeed, it's only since 1993 that the first article of the Belgian Constitution rules that Belgium is a federal state. In the meantime, in 1970, the 3 communities, French, Flemish, and German-speaking, were created. 10 years later, in 1980, 2 regions were formed, a Walloon region and a Flemish region. And finally, in 1989, the Brussels capital region was created in Spain. These dates, 1970, 1980, 1989, 1993, but also and more recently 2001, 2011, correspond to what it's called in Belgium a state reform. Each reform of the state leads to a new division of powers between the federal authority and the federated entities. These reforms also lead to a new distribution of financial resources and the creation of the refinement of mechanisms aimed at the management of political or legal conflicts between the components of the federal states. Belgian federalism is therefore said to be on a receding horizon. Next Sunday, the Belgian population will participate in the federal, regional, and European elections. The possibility of new negotiations, which may be leading to a 7th state reform, has animated the electoral campaign that ends this week. What must be remembered is that these various stages, which have embraced the federal logic, are unidirectional. Each time the state is reformed, the competencies and financial resources of the federated entities are strengthened, and consequently, the federal authority gradually stripped of its competencies. The movement is resolutely centrifugal. The second characteristic of Belgian federalism is that it's mixed, egalitarian but asymmetrical. Mixed because, as you have already understood, federal Belgium includes 2 types of federated entities whose territories overlap in parts, but whose competencies are in principle strictly exclusive. We have 3 communities whose competencies relate to language, culture, and education, and relate as well to several social services such as youth support or support for people with disabilities. The creation of communities is a Flemish request expressed almost from the beginning of the Belgian state. However, this request is only met since the 70s. We have also 3 regions, whose competencies relate to economic organization, employment, policy, mobility, the environment, and agriculture, for example. The existence of the regions was demanded by the Walloons elites. Since the 60s, these elites wanted to independently organize the reorientation of the Walloon economy after its gradual deindustrialization. The remaining federal competencies generally relate to justice and judicial organization, public security, defense, and to a large extent, social security and its financing through taxation. It's impossible to go into details here, but the evolutionary nature of Belgian federalism and its centrifugal logic have led to an extremely complex system of entanglement of competence, sometimes called as the Belgian lace paradigm. To take just one simplified example, the issue of fighting against global warming refers, among other things, to federal competencies, nuclear energy, and national transport, regional competencies, all other energy sources and regional transport, but also to community competencies, the major problem of insulating school buildings, for example. Legally, these entities produce norms that are equivalent to federal authority norms. Laws passed by community or regional parliaments have the same legal value as those passed by the federal parliaments. This is why Belgian federalism is called egalitarian. In other words, there is no hierarchy between the federal authority on one hand and the communities or regions on the others. This contrasts with other federal systems, Germany or Switzerland, for example, where federal law may in some cases be imposed on federated entities. The complexity of the evolving system of distribution of competencies which are always theoretically exclusive on the one hand, and the legal equality of federal and federated norms on the other hand, are two key elements that explain the deeply conflictual dimension of Belgian federalism. It moreover explains the corresponding need to multiply the mechanism for resolving conflicts, whether these conflicts are political or legal. Why is Belgian federalism said to be asymmetrical? Because each entity has what is called constitutive autonomy. This principle means that each entity can develop its institution as it wishes, except for its compliance with some principles, for example, electoral principles which are common to the whole country, thus, for example, the obligation to respect the proportional nature of the Belgian electoral system. The most spectacular measure adopted in the name of this constitutive autonomy is the fusion of Flemish institutions. The Flemish community and the Flemish region have since the beginning merged their parliamentary and governmental institutions. It anyway remains two quite distinct entities on the French-speaking side, even though bridges have been built between the Walloon region and the French community. The third characteristic of Belgian federalism is its simultaneous multipolar and bipolar dimension. Indeed, Belgium is multipolar because it includes three regions and three communities that refer to four cultures: Flemish, French-speaking, German-speaking, and bilingual Brussels. But at the same time, the entire federal architecture is determined by the historical opposition between the country's two main linguistic communities, the Dutch-speaking one and the French-speaking one. For example, if we look at the composition of federal institutions, we see that the federal government must include as many French-speaking ministers as Dutch-speaking ministers, but no Brussels or German-speaking people. Another example, the federal parliament is bicameral. The chamber is composed of 150 deputies divided into two French and Dutch-speaking language groups. The Senate have 60 members, all from community and regional parliaments. However, in the Senate, the representation of German speakers or Brussels natives is barely guaranteed and marginal. Also, the laws, the acts that organize Belgian federalism, acts that are qualified as special in Belgian constitutional law, require to be voted by the Chamber and the Senate with a special majority. A two-thirds 2/3 majority of the members in total, but with a simple majority within each of the two linguistic groups without reference to the German-speaking or Brussels pole, largely forgotten in the exercise of the competence of the competences. The constitutional courts, which arbitrate conflicts of jurisdiction between the federal authority and the federated entities, is composed of 12 judges, 6 of whom are Dutch-speaking and 6 of whom are French-speaking. And we could multiply the examples that illustrate the driving force of Belgian federalism is the opposition between French-speaking and Dutch-speaking people, with the German-speaking or Brussels people being rather the spectators of this conflict. However, the latter must assume some of its consequences. The bipolarity is reinforced by the fact that public opinion is divided in two camps. There are no longer any national political parties, neither there are national media, nor it's impossible legally to organize bilingual education, for example, even in Brussels, where each community has its own unilingual education system. It's impossible legally to finance a cultural institution offering performances in Belgium's two main languages, for example. More fundamentally, Belgian federalism remains terribly territorial. With the exception of Brussels, the communities, for example, cannot finance services addressed to their nationals living on the territory of another community. What matters is the territory in which you live, not your language or your culture. The consequence of these specificities, and I come to the second part of my presentation, is that Belgian federalism is both cooperative and conflictual federalism. The cooperative dimension of Belgian federalism is the product of the tangle of competences. It requires a series of mechanisms aimed at coordinating the respective exercise by the various entities concerned of their competencies. The Belgian federal system thus presents a rich catalogue of mechanisms requiring the different components of the Belgian state to talk to each other when the exercise of the competencies of one is likely to have an impact on the exercise of the competencies of another. Two simple examples of this. First, communities must notify the federal government when the exercise of their public health powers could impact state budget or social security, both of which remains under federal responsibility. Secondly, the regions are responsible for water policy and river management. When this water course crosses several regions, the regional governments concerned must consult each other in the exercise of their jurisdiction. Sometimes this obligation to cooperate refers to a joint decision-making procedure. For example, this is the case with regard to the financing of federated entities and the establishment of a distribution key for the resources transferred from the federal authority to the various communities and regions. It's important to know that the failure to comply with this multiple obligation of consultation, concertation, association, or joint decision-making provided by the special acts, that is the act that allocate competencies and resources, may result in the invalidity of the legislative or regulatory norm adopted in disregard of this cooperative mechanism. A particular and formalized form of federal cooperation lies within cooperative agreements. A cooperative agreement is defined by law as agreement that concern the joint creation and management of common services and institutions, the joint exercise of own competencies, or the development of joint initiative. They are concluded by the government concerned, and only a minority of them must be validated by the parliaments concerned. For example, those with a budgetary impact. But the majority of them are not public, and it's in fact impossible to determine the number of such agreements currently in force. 200, 300, 400. Even the greatest specialists in this field are unable to determine the numbers accurately. Some of these agreements are horizontal, meaning that they are concluded only by federated entities without any right of control by the federal authority. Some are vertical and include the federal authority among the parties to the agreement. Some are optional and are concluded when the parties deem it necessary. Let us take a recent example of horizontal and optional cooperative agreement. The French and the Flemish communities have recently concluded such an agreement to organize the exercise of their competence in radio matters and the establishment of a new digital broadcasting network. This agreement made possible for French-speaking radio to be accessible in the Dutch-speaking part of the country via this new digital format. Other cooperative agreements are mandatory. The Special Act requires that in certain matters such an agreement must be concluded. This idea of compulsory agreement is one of the numerous oxymorons of the constitutional Belgian law. For an example of such agreement, when following a transfer of competence, it is necessary to transfer the civil servants from the federal authority to federated entity that receives a new competence previously federal. The most well-known example of vertical and compulsory agreement is those concluded in the area of negotiation and international representation of the Belgian state within, for example, the European Union. Indeed, on the one hand, the federated entities in Belgium have international competencies within the scope of their own competence. On the other hand, many international treaties or European standards concern simultaneously federal, community, and regional competencies. These treaties are called mixed treaties under Belgian constitutional law. For example, recently, the trade treaty between the European Union and Canada, known as CETA, was blocked because the Walloon region and its socialist minister-president at the time, Paul Magnette, initially refused to agree to the CETA. This refusal temporarily blocked all negotiation between the European Union and Canada. So we know the end of the story. The Walloon region finally decided to give its agreement to the CETA following fairly intense political pressure from the country's other entities, among others within the Concertation Committee, a key body of Belgian federalism, to which I will return in a moment. So you see the main minister-president of each region and communities. It's not a constitutional cover of the Abbey Road covered album, but it's kind of. Three elements still need to be mentioned in relation to these cooperation agreements. First, these agreements cannot derogate from the system of distribution of competencies provided by the Special Act. Cooperative agreements cannot carry out a transfer of constitutional powers, although they can introduce in practice significant delegation of the exercise of such powers. Secondly, it is not very clear how they fit into the hierarchy of legal norms. Probably they are located just under the constitutional norms, but just above the legislative norms, whether federal, regional, or community. In the academic field, most authors consider that these agreements constitute a kind of international law internal to Belgian federalism. Domestic international law, yet another example of legal oxymoron. Third, in theory, the special law stipulates that each cooperation agreement should provide for an ad hoc dispute resolution mechanism on the implementation or interpretation of the agreement. In 20 years of Belgian cooperative federalism, none of these ad hoc arbitral tribunals has been set up, and in practice, such conflicts will be brought to the attention of the main political structure of federal cooperation, namely the Concertation Committee, which will be the subject of the second and final part of my presentation. Before that, a brief word about the judicial mechanism for resolving conflicts between the federal authority, the communities, and the region. A very important distinction must be made here between conflicts of competence, which are of a legal nature, on the one hand, and conflict of interest, which are of political nature, on the other. A conflict of competence is the case where a component of the Belgian state exercises a power that does not seem to belong to it. In this case, the component which considers itself aggrieved may refer the matter to the Council of State if the dispute norm is of a regulatory nature, or to the Constitutional Court if the norm is of a legislative nature. These two courts, Council of State and the Constitutional Court, have the power to cancel the disputed norm if they find a violation of the rules on the allocation of competencies. Conflict of interest is a vaguer concept that is intimately linked to the notion of federal loyalty. Indeed, the Belgian constitution provides that all the components of the Belgian state must, and I quote, act in accordance with federal loyalty in order to avoid conflict of interest, end of quote. The conflict of interest refers to the following idea. When exercising one of its competencies, a component of the Belgian state may harm the interest of another component, even though it respects the distribution of competence. Let us take a recurring example to fully understand this question. This example is related to the management of Zaventem National Airport. The airport management is the responsibility of the federal authority, but this airport is located on the Flemish territory and employs a large number of Dutch-speaking people. But the air routes followed by the takeoff or landing of aircraft mainly fly over the territory of the Brussels region, which is responsible for noise standards. However, the Brussels noise standards are considered too strict by the Flemish community, which considers that by restricting the possibilities of use of this airport, especially at night, the Brussels region is damaging Flemish interest. In such a case, the conflict is political in nature and seems to call for a political solution. But recently, 5 years ago, the Belgian Constituent Assembly blurred the distinction between legal and political by giving the Constitutional Court the competence to verify that the legislative norms adopted by the different components of the Belgian state do not violate the principle of federal loyalty. And the court does not refrain from using this new jurisdiction under which it may, for example, require entities in conflict to conclude a cooperative agreement in order to resolve it. So everything now seems to be in everything in the Belgian constitutional order. A court settles a political conflict by forcing the parties in disagreement to cooperate. Funny, isn't it? Even if I have to concede that Belgian constitutionalists have a strange sense of humor. Normally, therefore, a conflict of interest of political nature will be discussed within a political body, the consultation committee that I have already mentioned and that I will now present. This committee is in a way the monster of the Loch Ness of Belgian federalism. We know that it exists, but we don't really know what it does because no one has ever seen it. Officially and legally, this committee only intervenes in the event of conflict of interest via a relatively well-defined procedure. But the paradox is that first, in the exercise of this mission, this committee is rather ineffective. For example, the problem linked to the management of Zaventem Airport has lasted 20 years. Second, this committee should meet when a difficulty is observed in the work of Belgian federalism, even if the absence of any conflict. For example, this committee met following the March 2016 attacks in order to strengthen the collaboration of all the components of the Belgian state in the fight against terrorism. In a way, it was a response to the criticism leveled at the Belgian state, whose institutional complexity was pointed out in great bad faith as a failed state, allowing terrorist cells to be set up on its territory. Because everyone knows that terrorists are formidable legal comparatists who choose their hideout according to the institutional singularities of European countries. More seriously, according to the special act that provides for its existence, this committee is composed of 12 members. 6 members of the federal government, including 3 Dutch-speaking individuals and 3 French-speaking individuals, and 6 members from the governments of the federated entities, including 2 ministers from the Flemish community, which was merged with the Flemish region, 1 minister from the Walloon region, 1 minister from the French community, and 2 ministers from the Brussels region, including 1 French-speaking member and 1 Dutch-speaking member. There is therefore a strict linguistic parity with the German-speaking community is not associated, even if unofficially a minister of this community participates in the meetings. Second, since the sixth reform of the state that came into force in 2014, the Special Act now explicitly provides that the consultation committee is, and I quote, the central point for consultation, cooperation, and coordination between the state, the communities, and the region, and the regions to achieve common or individual objectives while respecting each other's competencies, end of quote. Finally, the law provides that this committee operates according to internal rules of procedure that it establishes itself and which are not public. These rules are decided by consensus. In practice, it results in granting a veto right to each of its members, which obviously does not facilitate decision-making within the committee. And that's all there is to say about the legal provision that govern the work of this committee, which is undoubtedly the most opaque body in the entire Belgian federal architecture. In practice, the secretariat of this committee is provided by the Chancellery of the Federal Prime Minister, which chairs its meeting. No agenda is public, no minutes are public, no link is established between this intergovernmental body and the federal community or regional parliaments, and the only information available is transmitted to the press by its members according to their goodwill or strategic interest. If we wanted to summarize the work of this committee and according to the confidences of several of its members, at worst, this committee acts a dissensus and refers the task of finding a solution to the conflict to the head staff of the political parties. At best, the committee refers the question to one of the many, more than 20, interministerial conferences that this committee can create. The special law provides for only one mandatory interministerial conference, the one on the coordination of Belgian foreign policy, which aimed to implement the cooperative agreements I mentioned earlier on representation and international negotiation. As the name suggests, interministerial conferences bring together representatives of the various executives concerned with a specific subject. In Belgium, you have such conferences in the fields of agriculture, education, healthcare, etc. Of course, the public, and to some extent parliaments, are largely unaware of what is happening here. And of course, like the nesting dolls, these conferences can also be subdivided into multiple ad hoc working groups. Let us take again the example of the fight against global warming that I mentioned earlier. In Belgium, the consultation committee set up the Interministerial Conference for the Environment, which in turn generated two other coordination structures, the International Environment Policy Coordination Committee and the National Climate Commission, each of which is subdivided into an incredible number of subcommittees and working groups whose competence overlap, which result? A structural inability to obtain an internal agreement on the sharing of climate efforts and an ability to represent Belgium in the COPs with a single, credible, and politically effective discourse. This example, which is not isolated, however, is full of meaning. Too many consultation bodies kill consultation. Or from a more cynical point of view, the less political will there is to solve a problem, the more formally this lack of will be hidden behind the multiplication of cooperation structures. Today, the paradox is such that several, mostly French-speaking political parties wished in vain to see yet another special act adopted that would oblige the components of the Belgian state to cooperate on this issue when precisely and formally this cooperation already exists. But following this example, however, a taboo has been broken in the Belgian federal psyche. Would it not be reverse the historical trend and consider that for certain challenges, a re-centralized policy is necessary and certain competencies should be redistributed to the federal authority? More recently, and very ironically, French-speaking political staff have expressed the wish to organize the COP26 in Belgium, a project opposed by Flemish political staff. In an attempt to resolve this disagreement, the consultation committee recently met, obviously without success. This would be the existential alternative Belgium would face today, recentralizing certain competences or disappearing as a federal state and moving towards a confederal state or even towards two fully independent states, although the particular situation of Brussels makes such scenarios highly improbable in the short or medium term. In any case, the example of the fight against global warming nuances an argument often heard in the mouths of informed political scientists. This organized opacity is the condition for the success of the negotiation that can be established within the consultation committee and its substructures. Anyway, from a democratic and also a scientific point of view, it is impossible to validly study this committee in the current situation. It would undoubtedly be desirable to democratize this body, which has been conceived as the nodal point of Belgian cooperative federalism and the main tool to managing constitutional litigation between Belgian national and subnational governments out of courts. Thank you.
I would like to have all the speakers back to the table, please. Thank you very much. We had another very interesting presentation, and I should repeat what I said about Switzerland. Every time we hear about Belgian federalism, things are very interesting and quite original, I would say. Certainly this is the case of the category of domestic international law, which is quite unusual from the point of view of legal dogmatics, but I think it represents very well the kind of basic structure which ultimately produces some results. Now, coming to the point which we are focusing here, that means out-of-court management of litigation, it seems to me that out-of-court management of litigation in Belgium is a sort of collateral effect of such a network of consultation and coordination that you have. In other words, it would be rather contradictory and perhaps also hopeless that after so much effort, you still have to go to court in order to decide an issue or a controversy. And in fact, the network that you described is very interesting from the sometimes mandatory, sometimes optional, the cooperative agreements, and in particular, at the end of it, the distinction between conflict of interest, conflict of competence, and also the fact that this situation encompasses two courts, not only one. As of course, I'm quite sensitive to the conflict of interest and the competence of the Council of State. In fact, we happened to talk about legitimate interest and administrative jurisdiction last night at dinner. Also, I think it is quite important to recall what you called, if I remember correctly, the Belgian paradigm, according to which the more serious a political problem is, the less likely it is that it will be decided by a court, which of course strengthens very much the network of coordination that we mentioned earlier. Also, I would say it is important to highlight what you described as the opacity, the lack of transparency of this system, and in fact this is also what I emphasize with regard to Italy. Whatever network of negotiation it is, sponsored or not sponsored by party politics, certainly it is not transparent and it doesn't lead to any form of democratic liability. And furthermore, we never know how effective it is, at least in the case of Italy, in the case of how effective it is in view of avoiding judicial intervention, whereas at least in the Belgian case we know that it is effective. So I think that we had 4 presentations this morning, of course 4 different stories, but they do have some areas of overlapping, and so we might have elements that will ultimately allow us to draw some comparative concluding remarks. Now we have about from 20 to 30 minutes for discussion, and anybody who would like to make a comment or to ask a question, and of course if any of the speakers would like to ask a question to other speakers or to make a comment on other speakers' presentation, you are all welcome to take the floor. Of course, we don't have an official discussant. I don't want to appoint one. Yes, please. Do we have a...
First of all, thank you very much.
I'm sorry, I asked for assistance for a microphone. There is one over there, which you may have to switch on.
Yeah, first of all, thank you very much, all the speakers, for these very rich presentations. I just want to join this aspect of opacity or of opaque negotiations. The question is, often conflicts are difficult to be settled because behind this are often political interests. And the question is it necessary in our decentralized federal systems to create such organs which are working, let's say, not in the light of the public? Of course, this is normally infringing upon our principle of transparency, which nowadays plays a very great role in all our discussions in the European Union. But I would be interested, perhaps the case of Switzerland, there I see it is discussed quite openly, I think, according to the tradition, but I would be interested how it is in the different countries, how you see it. Is opacity a necessary element of successful settlement?
Very good, thank you. Shall we collect 2 more questions before we give a first round of answers? Yes, thank you very much.
Thank you.
Yes. Thank you. Professor Andrew Harding from National University of Singapore.
Thank you. I'm aware that this discussion is really about what takes place outside the courtroom. But I'm just wondering, because I'm not terribly clear from the presentations, and my question is not directed to anybody in particular, whether constitutional courts or equivalent bodies in these 4 jurisdictions have in any sense taken account of the extra legal aspect of conflict resolution in making their decisions. For example, have they refused jurisdiction on the grounds that there is an alternative way of resolving the dispute, or have they assumed jurisdiction but made a decision on the basis of kind of encouraging a dialogic approach towards resolving the conflict?
Thank you very much. Professor Anna Gamper.
I'm just wondering how the genesis and also the age of federal systems comes into play here. Because if I'm correct, Switzerland is the only, let's say, original federal system. It is rather old. The federal constitution, of course, now dates back to 2000, but there have been 2 others before. Because I had a look at the case law of the Austrian Constitutional Court when I prepared for this lecture, and I found that in the first decades of the Austrian federal system, also the case law of the Constitutional Court was crowded with power conflict cases. But this has slowed down increasingly. So nowadays, of course, from time to time, a power conflict arises, but in very rare cases. So I think here we find that the decision was taken. We know how the court uses certain interpretive guidelines. We know what the interpretive methods of the court are, and so I think both the federal and the land lawmaker know mostly in advance how they should formulate their laws. So in the Italian case, for example, the allocation of powers dates back to 2001 mainly. So of course it's a rather young system, and perhaps it's only natural in a way that now for 2 decades almost there has been such a number of cases. Of course, if the allocation of powers is amended afterwards, or perhaps even if judges changed from time to time, the case law may change as well, a little bit at least. But the Austrian experience is quite different in this case. And another issue would be, this is an old idea of mine, I have to admit this, and I know it's not the real remedy in order to, avoid a litigation. But don't you think that if a constitution explicitly mentions interpretive guidelines in order to interpret powers, it might be useful? I found out when I compared federal constitutions in this regard that hardly any federal constitution explicitly entrenches interpretive guidelines. I found in the Devolution Acts, I found some guidelines how to interpret, let's say, a Scottish subject matter or so on. I don't know whether these guidelines are very useful, but it's interesting to see that in other constitutional contexts, there is a large number of constitutions that prescribes interpretive guidelines, for example, when it comes to the interpretation of human rights. But they are missing with regard to the allocation of powers. Could this also be a means to avoid litigation at the very beginning from the constitutional text itself?
Thank you very much. So shall we follow the same order of the presentations? Or you want? Shall we start from Spain or shall we start from Italy?
As you want.
Okay. So let's keep the same.
But I can, perhaps I'm not able to answer to all the questions. I think about the opacity of the process. The process before the court, it is a typical judicial process. In our court, in our constitutional court, has a praxis almost fully analogous to that of the ordinary judicial courts. We don't have the dissenting opinion. For instance, we discussed sometimes, many times, about the possibility to introduce the dissenting opinion, and the negative opinion prevailed on this ground because it is clear that the possibility of a dissenting opinion allows to know more precisely the arguments on which basis the decision is taken. And the arguments, of course, the arguments of a decision of the Constitutional Court are judicial arguments, are law arguments. And the main reason because for what we didn't introduce the dissenting opinion, and there are different opinions on the point. For instance, I was in favor of introducing dissenting opinion, but I was a minority. Well, the main reason is that not that the existence of dissenting opinions allows to know which judge have taken a decision and which judge has a different opinion. For instance, in our court, it is not possible to know the majority, how many judges have approved the decision and so on. There is only one possibility, because in the publication of the sentence, you can read the name of the judge who is the reporter, and the name of the judge who is the writer. I don't know, writer. And if the names are different, this means that there was a difference of opinion in the court, and the reporter, the judge who was a reporter, refused to write the decision. But the reason is that there is the fear that the existence or the possibility of a dissenting opinion may reveal the political position of different judges. Of course, a dissenting opinion is the reason of the dissenting opinion is to better know the arguments, the logic, which is in the background of the decision. But the fear is that that this is a judge of the right party. He took a decision different from what his party decided, and so on. Then the opacity of the legal, of the jurisdictional decisions. It is a reason of opacity. As for the extrajudiciary instruments, well, maybe there is less opacity, because normally in Italy all the seats inside in which there are discussions, or there are public. Is public. Is public. The discussion inside the Superior Council of the magistrature, for instance. Are public. The discussions in the parliamentary commissions are public. They are not public. The discussion inside, for instance, the Conferenze the conference, state regions conference, or state regions municipalities conference. They're not public, but everybody knows what has been told in that. Well, maybe in Italy there is one fundamental difetto, come si può dire, defect, the habit to transform a political difference into a legal difference, without speaking clearly, and see there is a political division. There is, I think this is a true defect. As for the political questions, the court seldom the constitutional court says this cannot be decided because it is a political question. Sometimes the court says, normally the court says the parameters of our decision are these norms, and on the basis of these norms, the decision is this, and not as a political question or a legal question. Without it is natural, a question discussed before the court is a legal question. The Constitutional Court, the court does discuss the political background, discuss only the legal argument, that sometimes are legal arguments which nascondono, come si dice, which hide real political differences of interest. But and as for the, I think you are right in saying that the age of a federal system is important because Italy is a very young, not federal, semi-federal system, very, very young. And the tradition of centralism in Italy is always prevailing on the constitutional system. Interpretation guidelines. The principles about the interpretation are shared in the judicial organs. For instance, we have in the civil code we have norms about the interpretation of norms. And say you have to take into consideration the express formulation of the norm, but the logic, the system, and the ratio, and
the
will of the lawyer, by will of lawmaker, well, but not in the sense that if the historical lawmakers had a will, that will must be the will of the law. We say that the law, when it is made, it is objectivized, and the ratio is the logic, the reason, the main reason which are on the basis of the law. That is, we don't have interpretative guidelines. We have a discussion about the consequence derived from taking into account one or another of the possible principles of the interpretation. For instance, a more formalistic interpretation or a more substantial interpretation. You have to give more importance to the words that the law uses, or to the spirit. This is a discussion inside the legal world. Also, among jurists, we say that some jurists are more formalistic and some jurists are more substantial. So, I think that as for the constitutional matters, the substantial consideration has always to be the principle, because Constitution is not a single statute, a precise statute which rules all the comportamenti, all the behaviors of the subjects. The Constitution contains principles, and the principles are the expression of something which is substantial, not formal. They're not so important as the words used in the law. There may be a very old law. There may be a law written when the juridical language was different from now, and so it's not so important the words we use in the law. But it is important to explain the spirit, the mere reasons which are, and the mere interest also which are on the basis. And also I think that in the judicial praxis, it would be necessary always to explain, to tell explicitly which are the principles suited, followed by the interpreter. Many times in Italy, the discussion is about the formalistic reference to this all that other. Maybe for an example, a recent example, a decree on the sicurezza, come si dice, security decree stated that the migrants who have chiesto richiedente asilo, come si può dire, apply for an asylum, cannot be inscribed in the registers of the communes, the municipalities as residents. Cannot be until the decision have been taken about their demand. Also for a long time, maybe one year or more from them. There had been a discussion also in judicial seats before judges, and some judge told that in spite of the words used in that law, it must conclude that the possibility, those who have demanded asylum can be inscribed in it for a constitutional reason, question of human rights and so on. But the discussion was about the interpretation. In this case, for instance, I hope that the question will be sollevata, will be raised before the Constitutional Court, which can decide explicitly referring to the main principle, human rights or not what is told exactly in that, what is said exactly in that law, but are human rights violated by this, by the negation of the possibility to be resident in a municipality, or are not violated? This is a substantial question. Well, in Italy, we have especially often a discussion in the courts and in the public opinion, which is more formalistic. Yes, and I don't think it is a good thing. And I think I have heard other reports. And I had the impression that the history and the explicit consapevolezza, aware that there are different communities, there are different languages, there are different interests, but it is necessary to cooperate. Well, in our culture, this is not so present. It is not necessary to cooperate, or there is an order from the height, or litigation, and it is certainly a very bad thing for our country.
Let me just say that coordination in Italy always implies that somebody coordinates from above. So coordination is never horizontal. Maribel.
Transparency, was the first question. Yeah, that's a criticism that has been made in Spain because it is published in the official gazette that the commission is about to be summoned, that has to be published. This aquí, ¿dónde? No.
That should be working, but
Yeah, it should be working, but
speak closer to the mic.
Maybe
Yes, it is working.
okay, yeah, it is working. So that is published. Also, you might find the agreement, the basic agreement. So in the website of the ministry, you find all the agreements that had been raised through the time. But still, what is missing is the reasoning why it was reached, and even when the Constitutional Court assets a withdrawal and the judgment that I have read, because they were partial, it does not explain why. So the withdrawal was made, and I accepted. But it is necessary, it is sound that everything is transparent. I have my doubts also. I think that that could be more difficult, the agreement. It is were to say out loud many things in public, but it's true that also with the secrecy can be used by government. So to give you a couple of examples, on the one hand, for instance, during these last months, one thing that was very problematic, that was about to be elections at the regional, at the national level. So in certain cases, it was better to wait for the commission or for the challenge after the election, and that probably has been used. Yeah, the weights. Don't challenge it, because then what gets to the news is only the title of the act, and that is if you are discussing something very technical, and we have a very stupid case on the hand of the rabbits. Everything they say is that the government is against the hunting, and it was not that. The point is who has to compensate the ones that they are eating their crops. That was the point of the challenge. But also, for instance, we have another case that I think that's interesting, how sometimes transparency is very good, because citizens understand more than sometimes governments want to think, was within the citizen initiative we have that at the regional level. So when the government tried to withdraw several challenges, the Catalan government said, we cannot make any agreement on these acts because they were a legislative initiative, and citizens would not understand it, etc., etc., etc. So they were trying, an agreement was sent, and the Catalan government said, no, it's impossible, we cannot. And they went to the news to say, central government does not want. Actually, the point was only one article. That was the mediation, that it was against the civil codes, how in the Catalan act was drafted. All the rest, the central government wanted to withdraw the challenge, but that was precisely the point. So from the ministry, they did not understand why there was not an agreement. So at the very end, the Secretary of State for Regional Policies went to Barcelona by train, met with the civil organizations that were behind the citizen initiative legislative, and said, you know, this is the proposal of the central state. We have only asked to amend this article. By the end of the evening, the Catalan government has said, we have reached an agreement, because these citizens went with him. So transparency can work both ways. So sometimes secrecy gives room for agreement, sometimes it's the other way around, because if you are not loyal, you can sell in different ways what is happening behind doors. So that's, I don't know if that for me is dubious, why it has to be more transparent or not. Then when it comes to the questions on which it has to do with the time, definitely yes. So if I didn't bring it here, but if you look at the race in Spain the first years, well, it was really many cases, hundreds of cases. And then it fall down because the court has already made clear many points. But it is also true that when we were going in a very good trend, falling down, then out of the blue it rises again with the economic crisis. So I would say it's the time and another kind of circumstances that might impact upon that. But I would say yes, that has to do. A guideline for allocation of powers in the Constitution. Okay, that's also a very old idea of mine, because I drafted my PhD on the interpretation of competence. I never remember I follow your writings. And I was writing probably my conclusion was another one. My PhD was on equality, so the power of the state to provide a general equality throughout the state. We will be 72 of the German constitution. They have it also in Italy, in Spain, etc. And when you look at the role of the court in human rights conflicts and the role of the court in competence conflicts is very different. I mean, whereas in human rights, yeah, you can change the perception through the time, but you are as court, you are promoting rights. But when you are in the middle of a conflict of powers, you are an arbiter. They are supposed to be equal. You can say the state is stronger than the region. Okay, not always. It depends on the country. It depends on many issues. So I would say courts have less tools, but I think there are good reasons for that. Because also, I think that they have to move with the weights, the courts. You know, this idea of freebies, no? That the federalism is changing. No? And if you look, for instance, on the German case, for me it was clear that when the 72 at the beginning, it seemed that there was an agreement of the social federal states, the court tended to decline, so to say, the jurisdiction. But then when things changed and the perception of the federal state changed in Germany, they even changed, if I recall correctly, the act of the Constitutional Court to instigate the court to make a different decision. So I say that the guidelines for me was quite tricky to find one and to put it in the Constitution. If Constitution is going to be a long Constitution, because we in Spain have tried to foresee everything. Perhaps that's why I got to a different conclusion. We have tried to foresee everything. If you look at the State of Autonomy of Catalonia, it's longer than the Spanish Constitution, but it does not work out. The meaning of the words is not plain. Lawyers always find a way to challenge an act, and here we are lawyers. If lawyers want, they will do it. And the general principles are the basic that the professor told before, but one that you can say, I think not, because really courts have to take into account the political situation, the strength of the different parties, whether there is a non-loyal cooperation. They can instigate it. They can foster. The Constitutional Court has called the parties, please come to an agreement, for instance, in the Catalan case. But if there is not, at the very end, what can it do? So that's why I say I didn't find so my conclusion of my PhD was like I don't have the answer for that, but I think it's quite tricky. Okay, I think.
Thank you very much. Eva Maria, take the microphone.
Well, thank you for all these questions. On opacity, I mean, transparency has become a paradigm, replacing almost everything else, including democracy. So when there is complaint about not being democratic, the reaction would be, we'll have more transparency, we'll have more public relations. So opacity and everything that is happening behind closed door has this very negative connotation. Not so much in my own country, where deal-making behind closed doors is quite a usual thing. Starting by the Federal Council, which is a collegial government composed by the magic formula, so including right-wing party members, socialist party members, and they have to agree. They could not possibly agree if the doors were open and the media present. So they meet every Wednesday and it's never public. No one has even the right to enter the meeting room. So it's just the seven and the chancellor, the secretary, and when they walk out, they keep it as a secret, and it's a legal duty to represent the opinion of the government only. There's not even a protocol. And we would find that very same mechanism wherever we want people to compromise. Because when the media is present, you have to be on your party line. And that is not conducive to compromise and deal-making. So yeah, I think that is extremely important for extradition agreement and for all the preventive measures. As for Andrew Hardy's question, doesn't really apply to the Swiss case because courts don't even get to speak up they don't get the cases in the first place, because you cannot challenge an act of parliament in front of the Federal Supreme Court. And if a case does get to the court, the judiciary does have a hands-off attitude. Even when famous cases about female voting, the first women challenging cantonal constitutions for not allowing them to vote, the Federal Supreme Court would say, sorry, these cantonal constitutions have been accepted by the Federal Assembly. There is separation of power. There's nothing I can do. So yeah, it would be hands-off. Anna, wow, that hard questions or comments. I think the age and is important. I mean, the codification of the Swiss constitutions, I think Roberto was the first person I heard quoting Article 44, because it's so deeply rooted in how the system operates, that it's so stable that we don't even need these rules. I wonder what we can learn from your remark about newly federalizing states, like Nepal. And what does that mean? Should they think more about extrajudicial mechanisms? Being prepared to take that load of that need to clarify things after constitutional changes. Like how to deal with the hiccups of a new system. Codification of interpretation. I think that would be such a wonderful topic for a seminar. Because methodology, constitutional interpretation is really the doorkeeper between law and politics. And constitutions are silent about it. Keep surprising me. Whether it's a living tree or more original interpretation changes everything. So in our country, this interpretation methodology is quite underdeveloped because the court doesn't get too many cases. The cases it gets are human rights cases. Here we will have dynamic interpretation. So I would like to discuss that more deeply with you. I would also have 2 questions to the other speakers, but I think that will interfere with your lunch breaks.
I think you should ask your questions.
Just 2 very short questions.
Yes.
One would go to...
Of course, it depends also on how short are the answers.
It's 2 very short questions. One for Maribel. I was very interested when you presented these, bilateral commissions. They can come up with agreements, and the agreement can be on interpretation, how you interpret what meaning you give to a legal act. Now that seems to interfere with the separation of powers. Is that interpretation then binding on the judiciary? And my second question, very much linked to that, since these negotiations and commissions are bilateral and asymmetric, does that mean that a national act receives different interpretation for the different regions? So that you have no longer a uniform meaning of your national law? But that's what I understand. But all the commissions are bilateral. It's one region. As for Julien, now all these mechanisms and commissions which are formed on strict linguistic parity, since you have so many constitutional reforms, couldn't you have one where we overcome this strict parity? And I think you were implying this in your presentation. Why not include bilingual people from Brussels as tiebreakers? Why not tiebreakers when you have 3 against 3, 6 against 6? If you would have people from Brussels sitting in this court and forum, I think there could be interesting actors in overcoming these, these even outcomes. And the same goes for the German-speaking community. They could be, I think, so interesting actors when it's all the political questions are reduced to linguistic questions. If you have a third actors coming in, could that not be helpful? Has that never been discussed when in one of these many numerous state reform projects? I'm speaking from my own experience, where we always have parity between French speakers and German speakers, but try to add an Italian speaker or a bilingual person, and it usually helps bringing an issue out of these ethnicized around, making it more political.
No, Maribel, no, it just recalls me the 3 members of the Constitutional Court of Bosnia and Herzegovina appointed by the President of the European Court of Human Rights, just to break the tie between the different communities in Bosnia. Maribel, you want to give an answer? And then we give the floor to Julien.
First the easy one. The second one. No, there is not an agreement on interpretation that is only applicable to a region. When it comes to the acts approved by the state, first, most of the agreements are related to regional acts, which makes sense. They have much more acts approved. There are 17, so most of the cases are regional acts. And when normally the agreements regarding the state to amend the act, table the bill in the parliament to amend the act, or to approve a ruling that will be applicable throughout the state when the act is to be developed in a further future. But they haven't found any that's not only in a region. That could be a problem. And then when the interpretative agreements are really problematic. When it comes to the follow-up, it seems easier because if me as administration have a duty to approve a specific rule, yes, it can be challenged before an administrative court afterwards if that ruling does not fulfill what I have agreed. That is more or less clear. If then what is an agreement of application, normally is that me have to send to my civil servants an instruction telling them this is how this word is going to be read. So normally this is tied to the case law. As the court said in this case, this is how this article has to be read. The only point that could be difficult, and we were discussing like 2-3 days ago, is when there are third parties involved. That would be a problem. And that is not so easy to be solved. As long as it is between administrations, can be settled. And in the very worst scenario, before courts. And it is a third citizen that is affected by that instruction. That is another level.
Thank you very much, Julien.
Okay, 3 quick answers or complementary remarks. In fact, Flemish political parties don't want a third people at the table. For the German-speaking people, for example, so it's the most protected linguistic minority in the world, no doubt about it, but it's maybe 70,000 people maximum. And for historical reason, German-speaking people are very attached to the unity of Belgium. They are fond of the king, for example. Everything Flemish hates. So it's no way the German-speaking people has something to say about the future of the great Flanders, And for Brussels, in fact, Flemish political parties hate Brussels for a different reason. The historic idea of the Flemish was not to create a Brussels region, but to create a model of co-gestion, a co-gestion of the capital, and that's why it took 19 years of negotiation to have finally a Brussels region, but it's not still yet considered as the same region as the Flemish or the Walloon. It's kind of sub-region for legal and political things, and I can't enter into details here. So it's a very bipolar system, and it's a kind of zero-sum game, in fact. And the problem in 1993, when the federal nature of the Belgian state was written in the first article of our constitution, there was quite of misunderstood. In fact, the French political parties thought at the time, okay, it's over, we're now federal. And it's the end of the federalization process. And of course, the Flemish political parties at the same time said, no, it's just a step. It's just a step to go further. And that's why I think the opacity is politically necessary, because all the negotiations in Belgium are inglorious bargaining, in fact. The opacity hides this kind of bargaining. For example, and this bargaining does not respond to any logic. For example, Flemish people say, okay, we want more power on immigration law. French people, since 1993, are claimants for nothing. So say, okay, no, we don't want. And finally, because they are poor, they say, okay, we give you immigration law power, but in exchange, you give us money for our school where it's raining inside. Flemish people want more power about social security. French people say, okay, but give us more money for the police in Brussels, for example. So all the negotiations are this kind of bargaining, and it's not very logic, so that's why it's hidden. And for the Constitutional Court, in fact, you must know that our Constitutional Court gives about 250 judgments a year, and maybe half of these number are conflict of competence. So it's more than 100 judgments a year about conflict of competence. Because the conditions for bringing an action before these courts are very few and not very demanding. So even me, any person, any individual can bring a case about conflict a conflict of competence in front of the court. So
His rights are affected, or
no.
like acte populaire?
No, yeah, yes. In fact, the Constitutional Court considers that everyone has an interest to have to the respect of the Constitution. so it's quite it's very contrast. It's a big contrast with the Swiss situation, and the fact that the court has for 5 years now the jurisdiction about federal loyalty can be interpreted as the failure of political way of resolving political problem. It's a kind of judiciarized political problem, and this new competence of the Constitutional Court are really blurring the line between legality and opportunity, of course.
All right. Well, thank you very much. I won't have any remark. I just apologize for the delay in finishing the session. At the same time, it shows how interesting the papers were and how stimulating the discussion has been. Of course, after the presentation of the afternoon papers, we may come back to discuss also the papers that were presented this morning. So thank you very much. We go to the same room where we had the coffee and tea break, where we're going to have the lunch break.
Yeah.
This room is here.